In this model, we are going to discuss trademark registration examination process. After filing application for trademark registration TMA form, the trademark office will examine the trademark applications. The trademark applications are examined by examiner. The word examiner includes any officer assigned the duty of examination of trademark applications. We can initiate expedited examination. The applications in which request for expedited examination is made on form TM63. By filing TM63, we can initiate expedited examination. The examiner looks at the application in detail and scrutinizes the applications. He looks at the application for three important points. The first one is whether the application has been filed in the manner as prescribed with reference to TM Rules 2002. Whether the application can be refused registration on relative grounds under Section 11 or absolute grounds under Section 9 with reference to TM Act 1999. If yes, the reasons. Whether any restriction, condition or limitation is required to be imposed in case of application is accepted for registration. The grounds for refusal of registration of a trademark can be dealt under two categories under the Act. Absolute grounds for refusal of registration under Section 9. Relative grounds for refusal of registration under Section 11. Relative grounds. The examiner shall make a trademark search. The trademark search is performed through the trademark system or trademark registry system. The examiner will find out whether any earlier filed or whether any registered trademarks which is same or similar to the description of goods or services. If same or similar earlier trademarks are found in the name of persons other than the applicant, then the examiner shall raise objection to the acceptance of the application for registration on relative grounds. How the examiner conduct the trademark search? The system enables examiner to make search with three modes: word mark search, phonetic search, and device mark search. The system automatically select the classes for search of earlier marks as per the application filed. The examiner may also add some more classes for search. The first mode of search is word mark mode. The examiner can make search of earlier marks on the basis of selected characters as prefix or suffix. The present slide shows word mark search mode of trademark search website of Indian Patent Office. Herewith you can enter your keywords, notify a class under which trademark is filed. You can use any other class for your further search. Another search mode is phonetic search. The examiner may specify one or more two phonetic variant of the trademark, and the system will fetch all earlier trademarks having phonetic similarity with the trademark filed. The present slide shows phonetic search mode of trademark search website of Indian Patent Office. Herewith you can write the keyword of trademark and a class under which trademark is filed. Another mode of trademark search, device mark search. The system enables examiner to find out earlier trademarks having same or similar features. Once the examiner completes the trademark search, then he will compare the earlier filed or earlier registered trademarks with the current trademarks. The three important factors the examiner will take into consideration for the examination of trademark applications. The first point is, what is the similarity and difference between the earlier trademark and the trademark in question? Second, how distinctive the earlier trademark is and the degree of similarity between the respective goods or services. A trademark application can be refused on relative grounds under Section 11. A trademark shall not be registered if, because of its identity or similarity with earlier trademarks, and because of its identity or similarity of goods or services covered by earlier trademarks. There exists a likelihood of confusion on the part of the public, which includes the likelihood of association with the earlier trademark. Example, Magnavox vs Multivox, similarity in words. Cresco vs Cresco, similarity in sound. If your trademark comes under the category of identical trademark or similarity of marks, they will not get registration under Section 11. What is the identical trademark? If your trademark is identical with the earlier filed trademark, your trademark reproduces the earlier filed trademark without any modification or additions. Your trademark constitutes all elements of earlier trademark. When viewed as a whole, your trademark and earlier mark contains differences, but those differences so insignificant that they may go unnoticed by an average consumer. The average consumer cannot differentiate your trademark and the earlier filed trademark. Those are the identical trademarks. So if your trademarks coming under this category, then it will not get trademark registration. The second type is similarity of marks. The term similarity of trademarks is to be construed as deceptively similar, which expression has been defined as so nearly resembling that other mark has to be likely to deceive or cause confusion. Means your trademark nearly resemble that the other earlier mark. It caused some confusion. Then your trademark can come under the category of similarity of marks. Another type of trademark under Section 11 cannot get registration, that is likelihood of confusion. For likelihood of confusion to exist, it must be probable. It is not necessary that actual confusion has arisen or should arise in the mind of public, that is the average consumer. After conducting a trademark search, the examiner may collect some earlier filed or registered trademarks which is same or similar to the current trademark which is under examination. He will compare the earlier filed trademark with the current trademark. There are some general rules for comparison of marks. They are: the trademark must be considered as a whole. It is not right to take a part of the trademark and compare it with part of the other trademark. No meticulous or letter by letter comparison is required. Side by side comparison is not the correct test. Comparison should be made from the point of view of a person of average intelligence and of imperfect recollection. The overall structural, visual, phonetic similarity and similarity of the idea in the two marks and the fact as to whether it is reasonable likelihood to cause confusion should be taken into account. Same trademark but for different use. Where the name or description of any goods or services appear on a trademark, which name or description in use varies. The use of that particular trademark varies in between the earlier trademark and the current trademark. Then the register may permit the registration of the trademark for those and other goods or services. So after comparing the earlier mark and the current trademark, if the examiner found similar or same earlier trademarks of different persons in respect of same or similar description of goods or services on the record, then the examiner should raise objection as follows. The trademark applied for registration is not registerable under Section 11. Since identical or similar marks in respect of identical or similar description of goods or services are there on records, and because of such identity or similarity of marks and goods or services, there exists a likelihood of confusion on the part of the public. So in this way, you may get objection from the exam. Till now, we have discussed about relative grounds under section 11 for refusal of registration. Now we are going to discuss absolute grounds for refusal of registration under section 9. The first point is lack of distinctiveness. Trademarks which are devoid of any distinctive character, that is to say, they are not capable of differentiating the goods or services of one person from those of another person, then those trademarks will not get registration. Second, if the trademarks are descriptive in nature, means trademarks which consist exclusively of marks or indications to describe the kind, quality, quantity, intended purpose, value, geographical origin, or the time of production of goods or of rendering of services, or other characteristics of goods or service, then those trademarks will not get registration. Third point, if your trademarks are generic in nature, generic means trademarks which consist exclusively of marks or indication which have become customary in the current language or in the bona fide and established practices of the trade, then those trademarks will not get registration. In the previous model, we have discussed about descriptive marks and generic marks. In the 1999 Act, the term distinctive and capable of distinguishing have been made synonyms. It means a trademark which is inherently distinctive or which has become capable of differentiating goods or service of applicants from those of others can be considered for registration. Why sign should be distinctive? The ability of a mark to identify and distinguish a good or service is known as distinctiveness. If sign is not distinctive, it cannot function as a trademark and its registration should be refused. We have discussed before what are descriptive signs. Descriptive trademarks merely describe some aspect of your goods or services without identifying or differentiating the source of the goods or services. They are only describing, they are not identifying, they are not differentiating the source of the goods or services. Some examples, creamy for yogurt. The word creamy is not identifying or differentiating the products. Apple pie for potpourri, bed and breakfast registry for lodging reservation services, world's best bagels for bagels. So these are the trademarks describing the goods or services. They are not identifying or differentiating the source of the goods or services. So they are called descriptive signs. They cannot get registration. Generic trademarks. Generic trademarks directly name the product. They are merely the common, everyday name for your goods or services. As such, they do not indicate source and they cannot function as a trademark. Therefore, generic trademarks are not federally registerable. Some examples are bicycle for bicycles. So bicycle is a trademark. It is nothing but name of that product. It is not differentiating the source of the bicycle. Bagel shop for a bagel shop. E-ticket for computerized reservation and ticketing of transportation services. So these are the terms, generic terms cannot get registration. Once after the examiner scrutinized the trademark applications, compared the earlier trademarks with the current trademarks, the examiner shall prepare his consolidated examination report. The report may have all the objections relating to formality requirements as to filing of application, objections to acceptance of the application for registration of the trademark, proposals for conditions of acceptance or limitation to use of the mark in case the application is accepted for registration. So this many details will be there in your examination report. If the examiner found some formality deficiencies in the trademark application, then the registrar shall send notice thereof to the applicant to remedy the formality deficiencies. And if within 1 month of the date of the notice, the applicant fails to remedy any deficiency so notified to him, then the application shall be treated as abandoned. Within 1 month of the date of the notice, the applicant must remedy any deficiency as notified to him. Otherwise, the application will be abandoned. If the applicant has submitted his reply to the examination report within 1 month time period, or he has appeared in the hearing and made his submissions, then the registrar shall pass an appropriate order. Every application for the registration of a trademark required to be advertised by section 20 in the journal, trademark journal. Opposition to registration. After advertisement of trademark application in trademark journal, within 4 months, any person can file a notice of opposition to the registration of the trademark. The notice of opposition shall be filed in the form TMO within 4 months from the date of publication of the trademark journal. What should be the content of notice of opposition? A notice of opposition shall contain the application number against which opposition is entered. Second, an indication of the goods or services listed in the trademark application against which opposition is entered. Third, the name of the applicant for the trademark. So these are the details should be given by opponent to the trademark office in the notice of opposition. Suppose the opposition is based on the earlier trademark or the earlier right on which the opposition is based. In respect of the opposing party, proprietor of the earlier trademark or of the earlier right, his name and address should be notified in the notice of opposition. Licensee not being a registered user, the name of the licensee and his address. Successor in title to the registered proprietor of the trademark who has not yet been registered as new proprietor. Where the opposing party has no place of business in India, then the name of the opponents and his address for service in India. The grounds on which the opposition is based. So these are the details should be there in the notice of opposition. So now once after advertisement of trademark application in trademark journal, any person, third party can file a notice of opposition. They will send notice of opposition to the trademark office. Once the registrar receives the notice of opposition, he will send this notice of opposition to the applicant. Within 2 months from the date of receipt, the applicant need to submit counter statement. Now that counter statement should be served by the registrar to the opponent within 2 months from the date of receipt of the same. So now the opponent received a counter statement from the applicant. From the date of receipt of counter statement within 2 months, the opponent shall leave evidence in support of opposition. Evidence by way of affidavit, as he may decide to adduce in support of his opposition. If the opponent takes no action within 2 month time mentioned therein, he shall be deemed to have abandoned his opposition. So now the applicant received evidence in the form of affidavit from the opponent. So within 2 months from the receipt, the applicant required to produce evidence in support of application. The applicant shall leave with the registrar such evidence by way of affidavit. If an applicant takes no action within 2 months time mentioned therein, he shall be deemed to have abandoned his application. Evidence in reply by opponent. Within 2 months from the receipt by the opponent of the copies of the applicant's affidavit, then the opponent may leave with the registrar evidence by affidavit in reply, and opponent shall deliver to the applicant copies of the same, including exhibits if any, and he shall intimate the registrar in writing of such delivery. No further evidence shall be left on either side, but in any proceedings before the registrar, he may at any time, if he thinks fit, give leave to either the applicant or the opponent to leave any evidence upon such terms as to cost or otherwise as he may think fit. Translation of documents. Where a document is in a language other than Hindi or English, and is referred to in the notice of opposition, counter statement, or an affidavit filed in an opposition proceeding, an attested translation thereof in Hindi or English shall be submitted before the register, and a copy thereof shall be provided to opposite party. Hearing and decision. The register, after the closure of the evidence, shall give notice to the parties of the first date of hearing. The date of hearing shall be for a date at least 1 month after the date of the first notice. If the opponent is not present at the adjourned date of hearing and at time mentioned in the notice, the opposition may be dismissed for want of prosecution and the application may proceed to registration. The registrar shall consider written arguments if submitted by a party to the proceeding. The decision of the registrar shall be communicated to the parties in writing at the address given for service. Application for opposition shall be made in the form TMO. The fee structure is 3,000 rupees for physical filing and 2,700 rupees for e-filing. The slide shows flow chart of trademark registration procedure in India. The registrar shall enter the trademark on the register where no notice of opposition to an application advertised or re-advertised. Where an opposition is filed and it is dismissed. In this case, the registrar shall enter the trademark on the register. The entry of a trademark in the register shall specify the date of filing of application, the actual date of the registration, the goods or services, and the class or classes in respect of which it is registered. So these are the details the registrar will enter in the register. Once the trademark is accepted for registration, then the certificate of registration to be issued by the registrar shall be on Form RG2 and shall include the trademark. It shall bear the seal of the trademark registry. The certificate of registration shall not be used in legal proceedings or for obtaining registration abroad. Application for renewal of registration. For renewal of registration of a trademark under Section 25, 10,000 rupees for physical filing, 9,000 rupees for e-filing, and the corresponding form number is TMR for renewal of trademarks registration. Application for renewal with the surcharge of registration of a trademarks under Section 25(3) for physical filing 5,000 rupees, for e-filing 4,500 rupees. Application for assignment transfer. The corresponding form number is TMP. For physical filing 10,000 rupees and for e-filing 9,000 rupees. So aspirants, in this model we have a thorough discussion about trademarks, trademark filing procedure, opposition procedure, refusal of registration, relative grounds, absolute grounds, section 9, section 11, renewal of trademarks, forms and the fee structure, etc. The details we have discussed here with will definitely help you when you register your trademark. Thank you so much.